Good evening, and welcome to Texas Talkin, the only show where we ask the questions polite people are told never to ask, and then we ask them again, slower, so everyone can hear. Tonight, let's talk about a court almost no one can name, but has the power to decide whether the worst criminals in Texas face justice or get a very comfortable delay. I'm talking, of course, about the Texas Court of Criminal Appeals. Sounds boring, right? Well, it's not. It's the final stop for death penalty cases in our state. Final, as in, this is where justice either happens or doesn't. Now, here's the part so many fail to mention. Texas voters overwhelmingly support the death penalty for the most heinous crimes: murderers of children, cop killers, serial killers, the worst of the worst, people whose guilt is not in doubt. Texans are very clear on this. In fact, crystal clear. And yet somehow executions get stalled for years, decades, on technicalities often so thin you could read the Constitution through them. Why? Because a handful of judges who most Texans couldn't pick out of a lineup have enormous discretion. And let's be bold here, my friends. This isn't just about the death penalty, it's about trust. If voters pass laws, if juries deliberate, if trial courts do their job, but a barely noticed court can override the entire process indefinitely, then who's really in charge? And that brings us to election integrity, because the Court of Criminal Appeals doesn't just handle death penalty cases, it also hears cases involving election crimes, fraud, ballot harvesting, illegal voting. The stuff we're constantly told either never happens or happens all the time, depending on who's talking. So here's the question no one on the cocktail circuit wants to ask, but of course we will. Do we want judges on that court who see their job as enforcing the law as written or rewriting outcomes they personally feel better about? Because if a court can quietly nullify the will of voters in death penalty cases, what makes us think they'd suddenly become fearless warriors for election integrity? Courts don't drift left or right by accident, folks. They drift because voters far too often aren't paying attention, which is why this race actually matters. Not in a flashy way, not in a cable news food fight sort of way, but in a rule of law way. Do we still mean what we say in Texas sort of way? Tonight, we're sitting down with a candidate, statewide candidate, for the Texas Court of Criminal Appeals, who says the law should be applied as written, justice should be timely, and voters, not activist lawyers, should ultimately be respected. Now, that alone makes him interesting. John Messinger joins us next. And trust me, my friends, you'll want to hear this. Let's get dialed in. And joining me now is a man running for a seat on the Texas Court of Criminal Appeals, my friend John Messinger. John, welcome to Texas Talkin'.
Yeah, great to be here, Shiloh. How you doing?
I'm doing great, my friend. Great to have you. Thanks for coming on. So, you are running for a seat on a court that practically no one knows about. And I want you, if you would, to talk to us for a little bit about what exactly the Texas Court of Criminal Appeals does.
Sure. Like you said, not a lot of people know it, but Texas has got two Supreme Courts. Us and Oklahoma are the only states that have that. We have the Texas Supreme Court for civil cases, and we've got the Court of Criminal Appeals for criminal cases. And they have three basic functions. They will review the decisions from the 14 courts of appeals around the state in criminal cases. They will have direct review of appeals from death penalty cases, and they will handle the thousands of writs that are filed by mostly people sitting in prison throughout the years. There's supposed to be limits, but they just keep filing things, and convictions keep getting reversed 15, 20 years later. I've got lots of problems, so we'll talk about the ones you want to talk about.
I want to talk about that, and I don't want to bury the lead here too much, my friend. And so I do want to talk about the role that the Court of Criminal Appeals plays, particularly in death penalty cases. If you would walk us through that.
Yeah, so typically what happens is you get indicted, and we'll just stick with murders because a death penalty is a murder essentially just a murder conviction with a very serious penalty at the back end. In a regular murder case, you get indicted, you get tried. If you get convicted, you have an appeal as a matter of right to one of your local courts of appeals. So if you're in Beaumont, it'll go to the 9th Court. If you're in Waco, it goes to the 10th Court, and so on. When the death penalty has been pursued and the jury answers all the special questions and assesses the death penalty, that appeal goes directly to the Court of Criminal Appeals. So it's one thing where they're actually reviewing a jury's decision as opposed to a Court of Appeals decision about a jury's decision.
And correct me if I'm wrong, Counselor, but those appeals are automatic. Those appeals are automatic, rather, right?
Yes.
Yes. Okay.
Yeah. And I mean, you can waive appeal. It's not never happened, but you understand most people don't want to be executed. So not only they're pursuing the appeal, and at the same time, there's a post-conviction proceeding where you get to complain about the things that don't appear in the record. Because normally on a direct appeal, you're stuck with what does the record show? And if your complaint isn't in the record, you can't complain about it on direct appeal. The writ is when you say, okay, but here's what my counsel didn't tell me. Here's this witness that wasn't presented. And so you get to complain about all these things. Normally that comes after the direct appeal. In a death penalty case, to speed things up, if you can believe it, they have that running at the same time. Things don't get sped up. It takes 10, 15 years, sometimes more, to get somebody executed. And not that any of us should be looking forward to that, but that is an important part of closure. It's something that we have in Texas law, and it isn't pursued quickly enough in the courts.
I want to talk about that in just a minute. Before we do, I want to drill in a little bit further on these death penalty cases, because I don't think a lot of people know this, and I'm not a lawyer, so perhaps my understanding is not correct. But as I understand it, the Texas Court of Criminal Appeals has the final say on death penalty cases, right? In other words, if the court denies an appeal, the governor of Texas can't intervene and stop an execution. Is that, am I wrong?
Oh, he can pardon somebody. I mean, you can go ahead, take the recommendation, a pardon recommendation, and do that. But in terms of the law itself, within, was the trial fair? On Texas law, the Court of Criminal Appeals has the final say. And that's true not just in death penalty cases. When our court screws up the Texas Constitution, we don't get to go to the United States Supreme Court for help. That's it. Like that's where it stops.
And perhaps I was confusing this. So the Board of Pardons and Paroles, they play a role in this whole process as well, don't they?
Yes, and you can go to them. It's very rare that they actually will give a recommendation. But lately there have been some cases, some of which are still going to be pending, and I can't talk about directly. But I know the cases you're alluding to, and so many of them end up getting tried publicly. There's a podcast. No offense to podcasts, but there's something where it just becomes very popular for people to chime in, and what you think you know about the case based on podcasts and Twitter, or now X, is very different from what the sworn testimony shows and what the findings of fact are going to reveal. So it's a very intensive process to review these things in the writ or even on direct appeal. It's an expansive record. And this is why those justifiably take a long time to do. You can file a case. It's some of the issues are just regular trial issues that you would have in any murder, but so many of them are challenges to the constitutionality of the death penalty. It's the same 14 or 15 things recycled time after time. It's I did one of these when I was in Waco. Thankfully, didn't have to do the jury charge issues, but it's somebody who committed his crime in the late 80s and then had his conviction reversed because he didn't have the chance to get into his PTSD from Vietnam. Gets a new punishment hearing, does not even go into any of that evidence. We reversed it. We spent a lot of time and a lot of money in Waco getting him resentenced. And that was before 2010. We got that done, and he got executed a handful of years ago. And this is the process, and this is families and victims.
So two things that I hear from most Republican voters anyway, and perhaps even Texans in general, about the death penalty. Number one, it is met with overwhelming support. Number two, people get very frustrated when they see people convicted of capital murder, death row inmates sitting in prison for 20 years before an execution takes place. What role, if any, could the Criminal Court of Appeals, the Court of Criminal Appeals, y'all aren't criminals, the Court of Criminal Appeals play in speeding up the process of justice without impugning the rights that everybody is entitled to who is charged with a heinous crime.
Right, and this is the tension. You want justice delivered. You want to get it right as much as possible. We're not perfect, so we follow the rules. We do the best we can to get the right answer, and then we pray about it afterwards. You have that, and then you have when these people sit around forever. You have obviously the victims of a capital murder aren't around to see it, but the family members. There are family members who die before they see justice for their son or for their daughter, and you can't have that. And so the role the court plays, a lot of times the delay is coming on the post-conviction side. You want to give busy trial courts the opportunity to take the time with the findings, have the hearings and do that. But a lot of times you'll see a case that gets remanded for a hearing and the hearing doesn't take place for 2 or 3 months. And then the hearing takes place. It's like, okay, well, we need findings on these. And the findings take a couple months. And you want to respect the fact that court has something other to do. They've got a regular docket. Trial courts are busy, especially in the counties that are more likely to pursue the death penalty because it's expensive. I mean, just practically speaking, it's expensive. So you want to give them the time because you want it to be right, but you don't insist upon it. And in fact, we had a record, a case last year. A poor court reporter just was not getting the record done. The case could not move forward because it had been 6 months, 9 months, a year. They had to bring her down to Austin and threaten her multiple times. It got to the point where they almost had to chain her to a desk at the courthouse to make sure it happened. And she, sad personal story on her end, but we're all waiting to get this done. And so I don't want to be in a hurry to say, you have exactly 6 months to get this done so we can get this guy hooked up. But when it's dragging on into its second or third decade, yes. And they have no look. If you're on death row and you know in your heart you did it and you got a fair trial, you have no incentive to hurry things up.
Sure, absolutely not.
And you remember a couple of years ago that they got on the presiding judge for saying, like, look, don't call us the day of the execution at 4:45 and tell us you need to keep the court open. Like, people, when you give people more time, they will take advantage of it to try to delay things for their client. And whether or not they think that that's being a good advocate for their client, it brings disrepute to the entire system.
Amen. Amen. I couldn't say it better. So, John, what inspired you to run for this seat? Tell us, if you would, a little bit about your background and why you are trying to make a difference on this court.
Well, I'm a career prosecutor. I went to law school at Baylor.
One of the good guys.
Yeah, we need good defense attorneys.
Of course.
I know you're joking, but I really want to make a point of this because it is so much harder to try a case and do an appeal on the other side from somebody who's not that fantastic. It's like punching Jell-O. You're always worried that someone's going to find somebody ineffective and you're going to have to do the whole thing over. So having somebody who, in a principled way, is making good arguments for the defendant, that is just so much easier. It makes us all feel better about the system and about the convictions. But I started in Waco, started as a line prosecutor, did a handful of misdemeanors, but very soon afterwards, the appellate person down there decided to leave. And that's something I fell in love with, interning with her when I was at Baylor. And so I started doing that. And right around election time in 2010, I got invited to come work at the state prosecuting attorney's office. Now, if there aren't a lot of people who've heard of the Court of Criminal Appeals, I would imagine there's about zero. There are still prosecutors who are finding out about our office. We're the smallest agency in Texas. There are 3 attorneys and a secretary.
Wow.
By statute, it is our job to represent all of Texas in front of the Court of Criminal Appeals. We could pull rank and do everything, but with 3 attorneys and a secretary, we just don't have the man. Actually, I'm the only man. We don't have the woman power to do that. So we pick and choose. And so mostly what we do is we review the decisions that go against the state in the 14 courts of appeals. We figured out if they got it wrong, because look, sometimes somebody didn't get a fair trial and they deserve to have another trial. But where we think the Court of Appeals made a mistake, or where they think they followed a Court of Criminal Appeals decision that needs to be reconsidered, we will see if they're going to do something about it. But more often than not, we're the ones who will take up the case. We frame the issue for the Court of Criminal Appeals. We do the arguments. The oral arguments, we do the briefing. And so in the last 15 years I've been working at the office, I've done those three things: the petition for review, briefing, and oral argument more than anybody practicing law in Texas. And so I've had a front row seat to it. And the last 4 or 5 years have been rough. Not only from a nuts and bolts point of view, where it's taking them it's getting a little bit better last year since the last election, but from 2014 to 2024, the time it takes them to do a review of a case, the main thing that they do, went up 2.5 times, or is 2.5 times as much, went up 150% to an average of over 500 days. Now that's an average. And you can imagine what it's like when you think that you have a point and you should be let out of jail, and it takes them an extra year to agree with you.
Sure.
Or if you're a rape victim and you have to wait an extra year or two to find out if you need to sit through another trial with your attacker. So even if you liked the opinions, that's unacceptable. More and more, I don't like the opinions, and I haven't liked the opinions. Again, I think we're in the middle of a turn. But in the last 4 or 5 years, there were way too many decisions from an all-Republican court. It is statewide. Everybody can vote for me. But an all-Republican court that did a lot of what I would consider not so Republican things, a lot of reversals on people who didn't get perfect trials, but their trials were as fair as required by the Constitution and by some of our statutes, and reversed anyway. And there's been no good reason for it. I've lost a good number of them personally, and I've had enough. And I complain enough about it. I'm watching it. I'm in a unique position to do something about it. God has given me a strange talent to do appeals. There's a lot of stuff I am not good at, Shiloh, I promise you.
Me too.
And again, only 3 people at any given time get to work at our office. So nobody has more experience doing this. In fact, over my career, maybe one of my friends in Harris County, and he's not 48. He's had a tremendous career, but when God's given you talent and an opportunity, you have to at least try. So when I get home tomorrow, I'll be about 21,000 miles into this campaign.
Wow. And it's statewide, so you're all over the place. I've seen you down here in Southeast Texas. And the next question, in fact, that I want to ask you about ties in to Southeast Texas, and that is the Stevens case. What role, if you want to talk about
the
that
people
for a
who
minute.
are aware of the Court of Criminal Appeals.
I'm sorry, I had some interference there. What role?
Lose you for a second.
Yeah, do you have me now?
I have you now.
Okay. What role does the CCA play with election integrity issues and voter fraud? I want you to talk for a minute, if you would, about the Stevens case and the implications that had moving forward.
Yeah, so in December of 2021, perhaps coincidentally, shortly after the filing deadline to challenge people on the court, they issued an opinion coming out of your neck of the woods. It was an election crime case. Broadly speaking, not massive violations of election crimes, but the sort of things that if you don't get after election integrity on the small things, you end up having bigger problems. And it was a case where the local prosecutor, for whatever reason, didn't want to pursue anything. And this happens. And it's something the legislature thought of decades ago, where you're going to have, it's either going to be awkward, politically dangerous, or maybe you just don't trust the local authorities to go after another fellow politician on a small scale. So the legislature gave the Attorney General's office the authority to go after election crime. And it took almost 40 years for somebody to challenge that statute. At least it was as it was last amended in '85. And that's what happened. The Attorney General came in, went after somebody, got the indictment, and they moved to quash. Basically, they said it violates the Constitution for the Attorney General to do this. And so, any criminal offense, whether or not it's in the penal code, would find its way to the Court of Criminal Appeals. But what they did here is not to review the statute itself, except to say, they decided it's assigning responsibility that should properly belong in their eyes to the judicial branch, because prosecutors are not executive branch. It's a weird thing in Texas. We're part of the judicial branch, at least according to the Constitution of Texas. We're in Article 5. And so they said the attorney do something typically assigned to prosecutors. And that's what the fight was over. It came down to basically it's Article 4, I think, Section 22, which describes in the Constitution the authority of the Attorney General. And it's the clause at the end. If I can just read it real quick.
Yeah, go ahead.
The Attorney General shall, whenever sufficient cause exists, seek a judicial forfeiture of such charters as described in the previous sentence, unless otherwise expressly directed by law, give legal advice in writing to the governor and other executive officers when requested by them, and perform such other duties as may be required by law. And so the fight came down to, well, that sounds pretty darn open-ended. And does it mean what it appears to say to a lot of people? And 8 judges on the court said no. We don't read it to be an explicit grant of authority. And I suppose it's not, in as much as it doesn't say the Attorney General can prosecute election crime. What it does say is, as he shall perform other duties as required by law. And I think that more than reasonably sounds like anything the legislature would want him to do, the Attorney General can do. And that was the fight. And that was the disagreement. And Judge Yeary was the only one who disagreed with the outcome in that case.
I know Judge Yeary.
And the weird part is he went on later. Yeah. And don't agree with him on 100% of things, but yeah. I love the opportunity to work with him for at least 6 years. I know he's already given 12 years of service to the state there. And so this was the problem. And, he raised an extra point on rehearing and appeals. I don't understand. And he argued that you're a defendant. You don't have the right to complain about who is seeking the indictment. Because in truth, people don't realize this. The grand jury can indict you without having a prosecutor in the room.
That's right.
It's the grand jury's indictment. So, and this is something where the entire fight could have been avoided. And courts generally have a rule to avoid messy interpretation fights with the Constitution if you can. So on a procedural level, they arguably failed. And then substantively, I know lots of smart people who agree with the holding in Stevens. I don't. I think it was wrong, and time will tell whether or not the legislature's fix is going to stick.
Yes, sir. John, if you would, please share with our viewers your final thoughts and why they should vote for you in this race.
Yeah. Thank God that most people don't spend a lot of time thinking about the Court of Criminal Appeals. Most people are blessed to live in a neighborhood where they're not worried about it. And most people have not been the victims of serious crime. And so it's easy to, with our limited bandwidth and everything else going on, maybe you have time to look at the legislative branch, watch what they're doing in Austin. If you have time to look at courts, you look at the Texas Supreme Court, because they're dealing with your business regulations and your tort reform and things like that. But Stevens showed that when you finally find out what the Court of Criminal Appeals is doing, the time to do something about it is 6 years ago when there was an election. And so I'm just encouraging people to really take a look at this court. And I joke, the Supreme Court, it's way easier for them to raise money because they're the money court. We just deal with public safety and civil liberties and sometimes life and death.
This stuff that doesn't really matter.
I'm hoping our court gets the amount of attention. Yeah, the little stuff.
Yeah, the little small things.
Yeah, and this is something, again, this court has been my life for 15 years. If it were running better, I would just keep being a prosecutor. I don't think there's anything better than my job. If I move on, I envy the person who takes over for me, but it's the time. I think I told you off air, my kids are 8, 6, and 4. So this has been a lot of time. It's been a sacrifice. My wife, Carrie's been a trooper. And so I'm looking forward to this being over on March 4th. Since I only have one opponent, I will know where God wants me, at least for the short term. Amen. And if you want to find out more, you can go to messengerforjustice.com. I'm John Facebook. I copy over to there. And that's all I can say. It's important. I'm thankful most people haven't been touched by the court, but let's get it running better before you are.
Well, John, I want to thank you for taking time to come on with us tonight. May God bless you, sir, and may God continue to bless the great state of Texas. Thank you for helping us keep Texas talking. Stay dialed in to interviews and content just like this by clicking that follow button on my Facebook page. Hit the subscribe button to learn more about exclusive access that you won't want to miss.